Is New Jersey a judicial hellhole? Let's find out. This is the Issues Watch podcast. Hi, I'm Jeff Kazerman, Vice President of Government Relations at the New Jersey Society of CPAs, and welcome to the Issues Watch podcast. New Jersey has always had an onerous liability environment for businesses. In fact, it's such a fertile state for lawsuit abuse that out-of-state trial lawyers often try to bring their suits here to New Jersey, even though the tide in New Jersey is usually tenuous. The situation has only gotten worse over the past few years with the passing of a plethora of laws that promote lawsuit abuse. With us here today to talk about this is Anthony Anastasio, President of the New Jersey Civil Justice Institute, or NJCPA, which is the largest tort reform association in New Jersey. The NJCPA is a member of that group and has had a close working relationship with them for years. Anthony draws upon diverse experience in both law and government affairs. He started out as an assistant prosecutor in Hunterdon County, worked for a law firm on civil cases for 10 years, and a few years ago, he joined the NJCPA. In that role, he does a lot of everything, including strategic legislative advocacy and public engagement to pursue the Institute's public policy goals. Welcome, Anthony.
Thanks so much for having me.
So can you tell us a little bit about the New Jersey Civil Justice Institute? What's its mission? What does it do? Why is it so important?
We were founded in 2007, and the mission is to keep our civil justice system fair and balanced. We represent the business community, so obviously we're looking for a system that doesn't tilt in any direction, pro-business, pro-consumer, pro-employee. We want it to be completely balanced in every case. So, I mean, that's, in a broad stroke, kind of who we are. One of our big fundamental things is ensuring that the rule of law is maintained in the civil courts. So we want, legal rules, statutes, regulations that are publicly promulgated so people are on notice of what's legal and illegal. It's clear, equally enforced, and independently adjudicated. So basically justice is blind no matter how big or small you are as a litigant. For everybody from a person to a multinational corporation, everybody's treated the same. All that's, I think, important in terms of making sure that the business community can do what it needs to do in terms of making strides in innovation, growing, creating jobs, and fostering capital investment. If they're going to get kind of broadsided by an enormous verdict that's based on kind of a loosey-goosey legal theory, they may not be as inclined to invest or innovate in the New Jersey marketplace. So, I mean, that's the best I can kind of capture what we are in a few sentences. We do a lot of different stuff. I can get into how we kind of go about doing that.
Well, we can hold, maybe that'll weave into some of the other questions here. So
Sure.
I think this next question will explain why it's so important to have your group. Can you give us an overview of the litigation environment that businesses face in New Jersey, especially in small and mid-sized businesses, since that's mostly what our members are, the kind of companies they work for. So what kind of wonderful litigation environment do we have here in New Jersey?
I mean, I think the best place to go to kind of convey that is, the recent study done by the U.S. Chamber of Commerce. They ranked our lawsuit environment as the fourth most expensive in the nation. So it's an average cost of, I think, $5,059 per household. It comes out to about 2.68% of the state's GDP. They did another study the end of last year that we were ranked 8th in the nation for the amount of nuclear verdicts that we have. So those are verdicts of $10 million or more. So in the whole country, all 50 states, we're number 8 as far as those types of verdicts are concerned. I mean, and that comes at a cost. Obviously, every business, consumer, family, it's all baked into prices. Depresses wages, limits economic growth, because obviously it's eating into, all that stuff. So medium-sized, smaller businesses, they're hit with that harder for, again, for obvious reasons. They don't have as much money to play with like the big companies do. They don't have access to capital markets like the big companies do. So it's going to hit them harder than it would a big company that can, go to Wall Street to get, capital at any time. Yeah, I mean, that's, I think, the best way to kind of make it hit front and center. I mean, they did these studies. I know that the lawsuit system cost study was based on a pretty reliable metric, which is insurance data. So, insurance companies are able to, they bring in information all the time through their business as to what they're paying out and, the cost of defense. And you're able to extrapolate from that to really kind of get a general idea of what cost is. I mean, there's self-insured entities and, there's other metrics that you kind of have to, take into account. But, I think that's the easiest place to go to get a real feel for which state's the most expensive.
Right. So how do we compare to like Pennsylvania, New York, Connecticut? Are they in the lower end like we are when it comes
No,
to
New York is higher than us. I think they may be at the top or second in the list. I think both per capita and there's a percentage of GDP. Have a lot of the same problems as far as, the type of laws they passed, a lot of liability expansion. Pennsylvania's further down the list, but they have their own unique problems. They have a system where their judges are elected. The plaintiffs' lawyers get involved in those judicial elections. And the Philadelphia Court of Common Pleas is kind of known as a really, really tough place for business. They have, new venue, I think a ruling by their top court allows pretty much anything to be filed there. Anywhere in the state you can file in Philadelphia, and you have a very plaintiff-friendly forum there. Because of the demographics and because of the the way the trial bar is just expanding its influence. So it's less costly, I think, overall, but they have their own unique problems that make their environment, depending on where you are in the state, extremely challenging. Their Supreme Court also is, I think, my understanding, is pretty activist. They undo a lot of legislative tort reform over there. So it's different. I wouldn't say it's better or worse. New York, I think, is worse, but Pennsylvania, I think, has its own challenges.
So getting back to New Jersey again, in 2022, we were on the American Tort Reform Foundation's Judicial Hellhole watch list. And I think at other times we've actually been on the list and not the watch list. So, and maybe this is an obvious question, why is New Jersey on that list? And do you think it's going to remain there?
I don't know. It's up to the American Tort Reform Foundation. I mean, I think, getting back to what you said about elected judges, I mean, we're fortunate in our state in that our judges are appointed similar to how the federal appointment process works, a little bit different, but I think that is a big part of why our judiciary in this state is so good. I mean, Jersey has a very good state judiciary compared to almost all the other states. You have a strong Supreme Court, very intellectually engaged. They engage in real jurisprudence, and your trial courts, you have professional judges who are they're day in, day out doing great work. Our appellate courts are, again, they're professional jurists who are not really politicians. They're judges in the sense like a federal judges.
Right.
So I don't think it really relates to that so much as some of the stuff that they think may be coming down the pike in our legislature. The plaintiffs' bar has an extraordinary amount of influence. They put a lot of money out on both sides. They have sympathetic. They have a sympathetic audience in legislative leadership. They have sympathetic audience in both parties. And I think the concern is that in light of that kind of backdrop, you're going to see more laws that are passed that expand liability, that make it easier to kind of hit these nuclear verdicts, easier to kind of bring class action lawsuits either in the consumer or the employment context. And I think that's where really a lot of it comes from. Also, our executive branch in the state has been very sympathetic to the plaintiffs' bar in terms of a lot of the environmental litigation that they've brought, in kind of cooperation with private attorneys, a lot of the wage and hour enforcement actions, and a lot of the appearances they've made in the state Supreme Court, kind of in support of some of these wage and hour class actions. So I think that's really the core of it.
Right.
Our judiciary, our Supreme Court is shifting. I think 5 out of the 7 justices will be appointed by Governor Murphy by the end of his second term. But we have a traditional kind of, it's a tradition, basically, where no more than 4 justices can be of the same political party. There's nothing in our Constitution that requires that, but for the most part, most governors have stuck with that tradition. It was kind of a split down the middle court. You had 3 Republicans, 3 Democrats, and 1 independent. It was like that for quite a while, and it was, I think, a balanced Supreme Court, and we're still kind of feeling out how this new court, as it takes shape, what it's going to be like. We've got some good decisions out of this new court recently. So my hope is that, the court kind of stays consistent in terms of being a place where you can really get a fair shake, whether you're business, individual, whoever. They're going to continue to be a high quality Supreme Court and a high quality judiciary. So I think that being on that watch list is more related to the 2 other branches, even though it's called Judicial Hellhole. I wouldn't characterize our judiciary as anything resembling a hellhole, given when you look at some of the other states with elected judiciary, some of the insanity that you see in some of the states and those counties. Like, we don't really have anything like that here. There are some difficult decisions coming out of our appellate courts that we've been dealing with lately, but again, it's not, some of the other states, some of the stuff you see, it's downright goofy. And you think you can kind of trace the line to the fact that you have the amount of money that comes into some of these judicial races from the plaintiff's bar. We don't have that here. So I think that's really where it comes from. My hope is that it stays that way, as far as the judiciary stays kind of a reliable place, where you can go and get thoughtful, decisions.
There were all these laws and regulations and new interpretations of regulations over the last 5 or 6 years. Very few of our members or the businesses they work for or their clients are aware of these, especially if they're not big companies, with the human resources department and so on. Can you just tell us about a few of these new laws or regulations, very broadly, that the businesses really do need to be more aware of?
I mean, I can go on and on and on, but I think, the number one thing that I think doesn't get a lot of attention amongst kind of the small, medium-sized business is this wage and hour liability that is, really kind of ramped up tenfold over the last, 7, 8 years. In 2015, there was a Supreme Court case in New Jersey that found that this test called the ABC test was what you would use to determine whether somebody is properly classified as an employee or an independent contractor. And that's a very hard test to satisfy for the employer. And then as a result of that, you have this, kind of perfect storm of incentives for the plaintiff's bar to pursue wage and hour class actions. And I think a lot of people they've been relying on these exemptions that they've had under the unemployment laws from the ABC test, which is where it comes from in New Jersey, for decades, thinking, okay, we're good. And anybody from the realtors to the insurance, brokers and agents, lo and behold, they're starting to get sued, not really realizing that those exemptions from the Unemployment, Compensation Act, there's been no definitive statement as to whether or not they carry over. So we've seen enormous class actions filed against these industries that have just kind of been relying on these exemptions for decades. And, we've got involved in them trying to support industry. But, that's the stuff that if I were a small or medium-sized business and I was relying on independent contractors, or if I had employees that, I'm relying on exemptions in the law to not pay them overtime, that's the stuff that I would be very, very careful with. Because I think the Wage Theft Act, it's a 6-year statute of limitations, triple damages for that whole period of time, and fee shifting. So say you're classifying somebody as an independent contractor and therefore you're not paying them overtime because you don't have to, independent contractor. And then somebody sues you and saying, no, they should have been classified as an employee. You should have been paying them overtime for the past 6 years. And by the way, if I'm successful in proving that to be the case, I get that whole amount from every employee I've been paid it to times 3, and I get my fees. I mean, you're talking about exposure that could put the lights out easily. And I'm not so sure a lot of these claims are really covered by insurance. I don't know if they have if EPL kind of riders cover this stuff or not. But I mean, you could easily have a situation where, you could have tens or hundreds of millions of dollars of liability against a business that just doesn't, they're not situated to absorb it. So, if I was a small, medium-sized business and I was relying on independent contractors, that's what I would be 100% laser focused on as far as compliance given. And then that's just the private exposure. I mean, the administration has just been, full bore in enforcing, these kind of new interpretations of, the wage and hour laws and worker classification. So you got to worry about it both from private litigation standpoint and from government enforcement. That's the stuff that would keep me up at night if I was using those types of workers, classifying me as such. I would want to make sure I had that solid. And frankly, a lot of the questions that we find ourselves asking about, well, what does this mean now? Is this person properly classified? Like, there's not really answers to it. So you can go to your attorney and ask, and they could be like, I don't know. Then it becomes kind of a, risk benefit analysis you have to engage in as a business person to determine, okay, is this worth the risk, continuing to classify? And that's what they want. They want to drive people with that uncertainty into total employee classification. So you get more payment in the government benefit funds, you get more union membership. And that's the end game of all this legislation and enforcement priorities. So, frankly, uncertainty doesn't necessarily hurt them. It's a good thing. People on the other side of this stuff.
Yeah, again, I don't think unless you have in-house counsel and I'm not sure, employment law lawyers on retainer or big human resources department, how can you possibly
You can't.
keep up with all this stuff?
And the thing is, a lot of these smaller businesses and medium-sized businesses, they have one attorney that they've been working with. It does everything, helps them out with business organization, litigation. Like, the wage and hour stuff is just so specialized, and you really you kind of have to go to some. And the only people who specialize in it happen to be the guys and girls who work at the big law firms that cost a lot of money. Yeah. So it's a tricky thing as far as compliance, and when you think about the exposure, you just kind of can't phone it in because it's so great in terms of how much you can get whacked on these class actions for this stuff. So that's there's any takeaway from accountants watching this. It's, their clients, even themselves. I don't know how, your members organize their, kind of, their worker relationships within their firms, but that's the stuff that you really kind of can't take for granted, given what's transpired over the last 8 years.
Right. Do you have any recommendations on what our members can do? And now I'm not talking about a big firm. I'm talking about, a solo guy or a firm with 5 or 10 people. Any recommendations on what they can do, broadly speaking, to reduce their liability exposure? I don't know. I'm just making this up, but maybe is there like companies that, put out special bulletins, you sign up with them and, so if somebody doesn't have a human resource department, or they don't have special counsel and advisors, they can at least get some of the biggest, hear about the biggest changes. Is there anything like that or anything else that you would recommend to our members and that they could recommend to their clients?
I'd say first and foremost, and there's a little self-serving kind of nature to this, support NJCPA, support the chamber, support BIA, join those organizations, CJI, get involved with your trade association. They're going to be following the stuff. They're going to be lobbying to prevent the stuff from happening. So you're helping in that regard, kind of, getting ahead of the curve. But they're oftentimes, the BIA is doing seminars on this stuff with attorneys who practice in this area, or the chamber. We do some of that stuff. I think that's a easy and relatively cheap way to kind of at least kind of have your head in the game of what's going on. And then, make sure you have it's tough with attorneys because they're so expensive, but make sure you have a good relationship with yours, and that, sometimes they're more reactive than proactive. And, while it may cost a little bit to call them up and, say, hey, what's the deal with this particular thing I read about, and, the Chambers magazine, and maybe that by reaching out to them will inspire them to educate themselves. They may not be dealing with this stuff until it hits a particular client. So you kind of have to be proactive. And it's, you're a small or medium-sized business. Like, I don't want to spend, whatever amount of time of that $400 an hour to make that
Right.
call, but
Yeah.
not doing it may be penny wise, pound foolish. And you may say,
Right.
oh, it's on the lawyer to figure it out. In reality, they're so busy with a million different things going on. Sometimes they're, it's almost a two-way street. So hopefully that advice doesn't sound too ham-fisted, but it's sometimes just what you have to do to kind of move the needle to make sure your advisors are following,
right.
what's going on in your industry. Is you have to be the one following it and make sure they're aware of it. Because they, the assumption that they're just following every little detail about your industry, I think is a flawed assumption. You kind of have to keep them in the mix.
So to put that in a summary, basically, your last points there were you're going to have to be proactive on watching and reading what's going on. Nobody's going to feed you this information on the independent contractors and the ABC test. And again, maybe if you're some big company with the human resources and, in-house counsel, they'll feed it to you if you're the CEO. But otherwise, you got to follow this in your local trade group, read the newspapers and wherever else you might hear about that stuff. And then if you see something you don't like and it's complicated, just spend the money and speak to an attorney.
Send them a letter. If you have somebody you deal with regularly, send them an email. Hey, I saw this, are you aware of this? This may affect us. You don't even have to ask for an opinion. Just keep them in the loop. I mean, look, there is a price to a bigger government, and that price is you got to follow more of the stuff that they're up to. The bigger they get, the more they do, the more you have to be aware of your rights under that regime. Right. It is what it is. So, I mean, as much as it's so many hours in the day, when you have a hyperactive state government like we have, in order to be effective in as a professional, you just have to put more time in to keep track of what they're up to. It's not a fun thing to have to, to do. And it's nothing, I take no pleasure in telling people that, but it's the nature of the beast.
Yep. Well, Anthony, thank you for joining us today. And I am sure we'll have you back for another pleasant conversation about New Jersey's great litigation environment. That was a joke. And I'm sure I will see you soon. We're always bumping into each other.
It was a pleasure. Always good to see you. Good to talk to you. And I look forward to coming back and enjoy your week.
Thank you.
Take care.
Thanks for listening and watching. To learn more about the New Jersey Civil Justice Institute, visit civiljusticenj.org. For updates on legislation that the NJCPA is supporting and opposing, visit njcpa.org/advocacy. And for employment law articles, events, and resources, visit njcpa.org/hub/employment law.